Don't forget about that.
Oh, yeah.
Sunday we lose and we spring ahead, as they say.
And we may never fall back.
We may never fall back, though. I'm betting that's probably not going to happen because Congress's history of doing things is pretty minimal at this point. I won't diverse.
We won't go there.
A couple of quick things, because Troy's got a fully packed evening for you, but as always, love to hear your feedback. We are in the process of trying to put together more and different educational events above the normal ones that we do. This is a great one we've done. We have the state of Indiana comes in and does the Medicare digital asset. Troy does that one. It's phenomenal. So there's a lot of different things, but above and beyond that, if you have some subjects that you'd like us to discuss or talk about, please let us know. We're in the process of improving it and trying to expand it a little bit. With that said, you probably know this, but first of all, on behalf of the entire company, myself and staff, thanks for sharing your friends and family with us. Over the past couple of years, we have gone almost exclusively 100% to referral-based business now. And it's because of your generosity in helping us share our story, we've been able to grow. We're going to continue to do that. We kind of do that in a unique way through fun events. We think it's better to get to know people socially, get to introduce us. If they want to talk about it, we'll give them that opportunity instead of sitting down at some boring dinner meeting talking about the latest annuity, stock, or mutual fund. So we're going to be a little different about that. There's some events on here coming up that will allow you to do it. We're going to have a couple baseball games at Victory Field this year. We've got a couple of suites rented. So if you know people that might be interested in at least meeting us, love to see you there. I do want to point out that on April 29th, on a Saturday here, we are going to have a shred event. Bring your friends, family, neighbors, we don't care. We have rented a commercial shredding company for the morning. I'm pretty sure we're going to have a grill out there with hot dogs and hamburgers, coffee, soft drinks, no beer. And we'll be shredding all Saturday morning. Bring as much as you want, and we'll be promoting it within the community. So keep your eyes open for that one. But that's coming up on April 29th. In May, Harley's going to do his ice in case of emergency. If you've never seen that before or been to that event, it's really worth coming to. He talks about a lot of the things that you don't think about, but what happens if you lose a loved one. It's amazing how many things we forget about that. We have the Indians game. We're going to do a cybersecurity again back in July. I think we did that last year for the first time. That's an interesting one. And then on August 5th, we'll have our halftime report at the Country Club. I think we're going to go to the routine where Harley does the one in February, and I'm going to do the one in August. Works for me because I'll be in Florida. We have an event at Topgolf coming up on August 10th. We have done that once before. Topgolf's a great facility up on the north side of town. Again, the idea is bring friends, bring family, bring acquaintances who may be interested in speaking to us. That's your cost of admission. And we're just going to socially get to know them. And then if they like to sit down and talk to us, we would love that opportunity. So pay attention to the sheet you were given. I'm not going to go through the rest of it. I don't want to waste your time tonight. But again, from the bottom of my heart, thank you so much for allowing us, one, to come alongside you, help you with your finances, and the other things that go along with it. Because quite frankly, Harley and I and Stephanie and Kathy Bellini and Jeremy, all of us believe that it's not just the finances, but it's the other things that make the difference, the estate planning, the taxes. And we've teamed up what we think are some of the best people in the city to do that. So a lot of you may or may not know this guy. His name is Troy Thompson. Troy and I have known each other longer than we're going to fair to admit because we're not that old. But Troy does an excellent job and has helped a lot of our clients with their questions. So he's going to talk about estate planning tonight. Again, it's great to see you all. Thank you so very much. Look forward to talking to you in the very near future. Have any questions, call us. We're here 5 days a week, 8:30 to 4:30. So with that said, have a great weekend. Enjoy it, and happy leap forward spring. Talk to you all soon. Thanks.
Thank you, Dan.
Troy, it's all yours.
All right, thank you. Thanks everybody for coming out. Winter is trying to make a comeback, so I appreciate the effort. It'll be easier to stay in and stay warm tonight. I do have to do the lawyer thing and give you a disclaimer before we start. I really enjoy presenting for RDW. Dave and Harley and Jeremy do a great job. They have a heart for education. I do as well. That said, I am me and they are them. When we're not related, Whether you do business with me or not doesn't help you in their eyes, and vice versa, although I'll never tell them that. So just understand that we're two separate entities, we're not financially tied together. And the other thing I have to always say is, we're talking in generalities here. Your specifics may not apply to the examples that we give and vice versa. And just because I'm talking and you're listening and asking questions, it doesn't make us attorney and client. So just, that's what I have to do as a lawyer, to tell you the little disclaimers. And with that, we can dive right in. Have any of you been here before for just like a estate planning basics? Okay, several of you. Normally, when we do that at basics, it's just a kind of an overview, and we kind of start as you're just entering, you're just getting your toes in the water, and we come at it from a conservation, estate conservation aspect. We talk about wills, trust, advanced directives, that's for like power of attorney and health directives. And we've also talked about digital assets. In addition, we have a separate program for digital assets all on its own. Tonight, we're going to go beyond the basics. So if you've not been here before, you're still going to get a lot of good information. And you can stop and ask some questions. I'll be glad to try and make sure that it fits with your understanding. But we're going to take a little bit of a deeper dive tonight. We're going to talk about some updates for taxes, some updates on digital assets, some updates for healthcare directives. Then we're going to get into deeper talking about IRAs and why they don't always play nice with other estate planning ideas. And then lastly, we're going to talk about trust, and trust as really are the superheroes of estate planning. So that's kind of just an overview where we're going to go. We're going to take a brief detour on the updates and then a deeper dive into the IRAs and the trust. So let's get started. Tax law is always changing. The news today, I think the president rolled out his budget proposals and the new taxes, and so there's always tax law changes. But in this particular arena, it's a fairly stable tax situation, and that's good news. The federal estate tax is still out there. But as we sit here tonight, each person can pass $12.92 million before they owe any estate tax. So that excludes most of us, if not all of us. And you can double that if you're a married couple. So the first $25 million, give or take, is tax-free for a married couple. So for most people, estate tax is the federal estate tax, not a problem. If you want it to be a problem, then that's, you tell Dave to work harder. The gift tax, how much you can give out each year, just kicked up another 1,000 this year, because these are all indexed for inflation. So it just kicked up another 1,000. So you can give $17,000 to anybody you want, and you don't have to report that. You don't have to explain it to anybody except your spouse. But there's no tax on that. So that's always a handy one to know if you're trying to spoil grandkids especially. And it's not really an update, but just a reminder, Indiana does not have any kind of an inheritance or an estate tax. So when we think about what we would consider that group of kind of death taxes, estate and inheritance taxes, you're really free as a resident of Indiana, you're really free from those concerns, which is nice because it leaves you to focus on the other details in your planning. I will mention that the current law for the $12.92 million, that's based on $10 million being indexed for inflation. That's the Trump tax cut. That has a sunset in 2025. It'll go back to $5 million indexed for inflation, so it'll be roughly half that. Normally, when Congress is faced with sunsets, they just keep extending them and they eventually become permanent. But given the animosity that they have for Trump, it would not surprise me if they actually let some of these tax cuts sunset. So just be aware of that. It may drop down and you may start looking at a $5 to $6 million threshold before you have to pay taxes. That still, for most people, still pushes it out, especially for a married couple. Being able to double that pushes it out where you don't have to worry about it. But it is out there, and that'll come rolling around after the next election, of course. That's the way they time it. And a quick update about digital assets. When we started talking about that probably 4 or 5 years ago, there was a lot of turmoil, but they have this. The federal government is still way behind, but the states have taken the lead. Most states now have what we call a uniform law, so it's the same in every state. You get the same result no matter what state you're in, and that really helps. We have a stable legal platform, which means we're able to plan for it. We know what the law is going to be, and we can work around that. The key in all of it is to make sure somebody can access your accounts. So if it's an online password diary, if it's written on the back of a phone book, whatever you do, make sure somebody can access your account, somebody that you trust when you die. If they can't, then we have to go through the court to do that. So even if your entire estate is gonna go in a trust or something and it doesn't have to go to court, we would have to go to court just to tell Google to let us read your email. So we can figure out what accounts, because probably everybody in there has at least one bill per month that doesn't come on paper anymore. It just comes through the internet. And it's always important with digital assets to know if all those movies and songs on your iTunes account or whatever digital account you have, you think you own them because you bought them, but you probably don't. You've probably licensed them for your lifetime. So there's another great reason to provide access, because if you call Apple and report the death, they'll help you maybe get into the account so you can get things, but they will also go through and say, well, the license is up on all that, on all those movies, all those songs, and delete it. However, if somebody that you trust has the password, Apple never knows the difference. So we're talking as friends now. So this is, can't stress enough, just make sure somebody knows how to get into your computer, knows how to get into your accounts, and that needs to be updated from time to time as you update your passwords. I want to talk about some updates to the healthcare law, and we're going to take a few minutes on this one. It's been about 30 years since Indiana has updated their laws concerning healthcare decisions and access to healthcare information. So through the years, there have been a lot of changes, federal and so forth, so you end up with a patchwork of laws. And so different laws doing different things. The federal law came in the 90s about HIPAA, about who can control or who can has access to medical information. Indiana is very persnickety, or they were, about the official language that has to be in a living will for it to be valid. So if your living will comes from another state, it may not automatically work here. So I did a little count, and you could have healthcare powers in your power of attorney. You could have in a separate document called appointment of a healthcare representative. You have instructions in a living will. You can have instructions in an anatomical gift declaration. You have a HIPAA authorization for information, a do not resuscitate order if you're older and you get one from your doctor, and a declaration about your funeral arrangements. That's like 7 or 8 documents. And you may do a power of attorney in 1 year and a healthcare document 5 years later, they may have different people in them. So it was just very complicated, very confusing. There were a lot of complaints from the medical community and from the legal community. So January 1st, the new law is official. All that can go in one document. That's quite a document, though. I mean, that's a lot of information to pack in one. You got to be careful about that. We'll talk in a second. There's no more official language requirement. And they also use some of the technical requirements, which means the old documents, some of them had to be notarized, some of them had to be witnessed, and now it's obvious it can be either or, and it can be common sense. What I like to tell my clients is now your documents can actually say something. I don't know if you've read through an older living will, but basically it comes at the framework where you're on death's doorstep anyway. And so it's, by the time somebody wants to read the living will and apply it, there's probably not much chance you're going to recover even if you wanted to. Now you can get more proactive with that. So and there's no official form or set of guidelines from the state of Indiana. So a lot of clients go to what's called 5 wishes. They have a very kind of conversational approach to these decisions, and it pulls in not only legal and medical decisions, but also just kind of the emotional aspect of it. The state of Indiana has what's called a POST, P-O-S-T, order. And that is something that you can download online, and you just post order, P-O-S-T order, for state of Indiana. It's a form you work through with your doctor. And I'm always a big fan of medical decisions being between the client and the doctor, rather than the client and a lawyer who have no interest in medical school. So it's a lot better in a lot of ways. It's very much a common sense approach. But you can pack all that information into one document, which means you got a lot of power and a lot of information in one document. So I always encourage people, you need to be a little more careful in how you handle those and who's got access to that information. There's no longer a requirement for incapacity So a lot of these decisions, a lot of these powers can start as soon as you sign a document. And because there are so many important decisions in one document, I always encourage clients to review those more often now. Your health changes. I mean, 4 years ago, who would have known what we were going to face healthcare-wise? So it's important to review those. But overall, this is a very positive change. The documents you have now are not void. They still are in effect. So there's no reason to run home and panic and think we've got to do this right away. But it just makes sense as you go through your updating process. Read those. Do they still make sense? Is this still who I want making my healthcare decisions if I can't? And if not, we can take advantage of the new law and kind of hopefully streamline that a little bit more. Does that make sense to everybody? Just a few quick updates. All right, let's dive in and talk about IRAs now. IRAs are an incredibly good financial tool. They have really been powerful through the years to incentivize people to save for their own retirement. And the planning was, the concept was when they started, you would put your pre-tax dollars in there, so it was a tax deduction right now. It would grow tax-free through the years. When you withdraw it, it would be income to at that point. And the original thinking was, well, your tax rates would be lower in retirement, so it actually would be a net tax savings for you, as well as you saving for your own retirement. It's not really played out that way tax-wise. Actually, you may end up being in the same bracket or a higher bracket when you retire. So it doesn't always, the math doesn't always work the way it was intended, but they are still incredibly good programs. The Roth is a very good option too. Roth, you don't get a tax deduction right now. So you're going to grin and bear it for now, but it's going to grow tax-free. And then when it comes out, it's all tax-free. What you put in and what grew. So that's a broad overview of that. So they are incredibly good financial tools. But from an estate planning aspect, they don't always play nice. We're going to talk about why. So I jumped ahead of myself. I told you about the two styles there, but traditional pre-tax, we grow tax-free, it's taxed at distribution. Roth, you don't have any taxes because you're going to pay them up front. The beneficiary rules changed back in 2020. If you are the beneficiary, when you get to the age where you are having to take out the money for required minimum distributions, and I do want to qualify, we are now talking exclusively about traditional IRAs. So we're going to park the Roths over here. This is all the traditional IRAs. So when you get to a certain age, the government says that's long enough, take the money out and pay some taxes. So you have to do required minimum distributions. The money comes out, it's taxed at whatever your personal rate is when you withdraw it. If you pass away and you name your spouse as the primary beneficiary of the IRA, it is allowed for them to roll it directly over and make it their own IRA. So they get treated just like you. They have their entire rest of their life based on their age to take it out. They'll have required minimum distributions. They pay at their personal rate. So that's pretty easy. If the spouse is predeceased or when the second spouse dies, typically whatever is left, you name your children or some other person as the beneficiary. This is where the rules changed. The rules now are that that person, with very few exceptions, if it's not your spouse, that person only has 10 years to take that money out of the IRA. So they can do it all in year one, they can do it in 10 equal years, however they want to arrange it. They're going to have to take it out. And it's taxed at their personal rate. We're not punishing them on a tax rate, we're just forcing them to accelerate the withdrawal. If you say, well, I have other ideas for my IRA, I'm going to actually leave my IRA to my estate, because then I'm going to put some detailed instructions in my estate about, parceling it out to, various organizations that I like, or my nieces and nephews. That's fine. You are allowed to do that. The estate still has the 10-year window, so they have to get everything out in 10 years. They're taxed at a fiduciary rate instead of a personal rate. That's essentially double. So you gain the ability to do what you want, but you get hammered with taxes. If you say, well, I'll just leave my IRA to the church or to the Humane Society, that's fine. There are no taxes because you're actually leaving it to an organization. So that's actually a nice thing to do. You've just leveraged that. You didn't pay income tax on it. They're not going to pay income tax on it. So you've leveraged your gift that way. So why is this a problem? Well, the problem is that the beneficiaries aren't always smooth. They're not always how you want them to be. If you have a problem with yourself as a beneficiary, I can't help you. But when we think about the spouse as a beneficiary, well, is this a second marriage? Because oftentimes when you get in a second marriage, you start to get a tension between a tension, not a tension, but a tension between wanting to take care of your spouse, but also take care of your children from your prior marriage. So they'll start to pull at each other a little bit. And if it's somebody other than your spouse, are they over 18? Are they responsible? Do they have issues in their life? And we're going to take a hard look at that in a little bit. But are they fit to get that, or are they going to pull it all out on day one and squander it? If you leave the IRA to an estate or a trust as beneficiary, then you've doubled the taxes, and the church and the charity don't present a problem as a beneficiary. So it seems like perhaps a kind of a narrow window of when you're going to have problems, but I've been doing this for over 25 years, and this comes up over and over and over and over. And sometimes it's just as innocent as there's nothing wrong with my kids. They're just too young to be responsible with $400,000 of IRA money. They won't understand what to do with it. And I can't leave that to chance, so what are we going to do? And as I said, what you get is this kind of a tug of war between control and taxes. But you get the most control if you put it in your estate, because then you can dictate down to the penny what's going to happen to it. But you're going to pay a lot of taxes. So how do we do that? The options, well, I'll suffer the taxes, but I want the control. I do see this come up sometimes if beneficiaries have substance abuse problems. There's no amount of taxes that are too much to pay just to make sure that the beneficiary doesn't have access to the money. Change to another person. I've seen this done a couple of times. I'll make my brother the contingent beneficiary. I know he'll do what's right for my kids. So I don't have to go through that higher tax bracket of an estate or a trust, keep that personal rate. But ultimately, I am losing control. I'm sure my brother would do what is right, but what if he dies? Now what? Or maybe I overestimated my brother. Maybe he won't do what's right. And as I kind of mentioned, you can change to a church or charity and eliminate the taxes, actually leverage your gift. But then you have to go back and kind of reshuffle the entire deck on the estate. Well, I'm giving that much to church and charity. I got to figure out how I'm going to treat my spouse and my kids equally, and so forth. So it requires some more thought. So there's not really any clear, easy path. There is a possible compromise solution using what's called an IRA trust, and sometimes you'll see them referred to as see-through trusts or retirement trusts. And they're a very technical trust, and what that usually is used for is to just pace the beneficiary. So it will leave the IRA to a trust. So the trust then has 10 years to take it out. And the trust can take it all out in year 1 or all out in year 10. They may have to take, depending on your age when you die, they may have to take a little bit out each year to keep up with RMDs. But for the most part, the trustee sets the pace at when it's going to be withdrawn. The catch is, whatever is withdrawn has to be turned over to the beneficiary that year. And if you play by those rules with the IRS, then the IRS won't tax you at the trust rate. They'll tax you at the personal rate. They see through the trust and look at the beneficiary as the taxable party. So if to make it easier, we'll make the math easier on ourselves. There's $100,000 in there and the trustee says we're going to take it out $10,000 per year. The beneficiary can still go squander that $10,000. We don't have that much control. But at least the beneficiary can't come back for the other 90. And if the trustee saw that, the trustee can say, well, year 2, we're not going to do any distributions. So you get some help and get some counseling, grow up a little bit, whatever the need is. So it's not a perfect solution. It is definitely a compromise. You gain a level of control without getting hammered on the taxes, but it's not a perfect solution. The idea here, though, is definitely that IRAs have to have attention on how they fit in with your estate plan. You can't just plug them into a trust. You can't just plug them into an estate. If your beneficiaries are wonderful people, great, they've solved themselves. But when the problems come up with the beneficiaries, then the problems feed over or bleed over into the estate planning. So you just gotta get creative in how you approach that, and maybe the right solution is to start thinking, hey, I'm gonna do some charitable giving from my IRA, then I don't have to worry about it. I will also definitely plug the concept, and I am not a financial planner, that's their job. And in fact, I think in November, they're having a seminar just about conversion to Roth. There are a lot of financial reasons that you may want to consider converting to Roth, even without worrying about your estate. But if it makes sense to do, remember earlier I said we were parking the Roths over at the side because all these complications come up from traditional IRAs. If you convert your IRA to a Roth, you're basically just planning a bank account. You can put that right into the trust. It doesn't cause any problems. There are no required minimum distributions. There's no 10-year timetable. It's all coming out tax-free, so Uncle Sam's just walked away. It has no interest in it at that point. So you really are free to plan, at that point, plan how it makes sense for you and your beneficiaries. So does that make sense? Any questions about IRAs and how they fit in with the states? Sir?
If an IRA beneficiary was, let's say, 4 kids, they have 10 years to withdraw it, but any one can't take out any more than 25% if it was equal beneficiary.
Right, they have their 25%, and so one child may grow it and do the right thing with it. The other child may be in Vegas tomorrow morning.
Right, so but they'd still be limited by the,
Yeah, by their, they can't get to their siblings.
that share. Yep, very good question.
All right. Let's take a little deeper dive with trust then. And I promise you, this is as corny as it gets, okay? It's all level from here. Trusts are superheroes, they really are. There are very few estate planning problems that cannot be solved with a trust. It's just a matter of how far you're willing to take the effort, how far you want to commit to a trust. So to borrow Superman's old introduction, they're faster than the best probate court, they're more powerful than the nosiest neighbor, and they are able to leap over any difficulties with it in a single bound. And I say that just to remind back from, if you've been to the kind of the basic planning, trusts are private, they don't have to go to court, they're not reported to any of the neighbors, and those are important things sometimes. That doesn't make a difference to a lot of people. Most people are just interested in what it can provide me as far as a financial benefit to my heir or some way that I can protect things. But they have a lot of great benefits. It all boils down to one common theme though, and that's to be able to control things from the grave. The trust is built to take over when you can't run it anymore. And that's either when you're incompetent or when you pass away. And what we're trying to do, 90% of the time, we're trying to protect beneficiaries, we're trying to protect the assets, or we're trying to, the assets as the assets, or we're just trying to protect the wealth period, which means we're trying to get some tax advantages. That's what trusts are there for. So let's do a deeper dive here into protecting beneficiaries. We talked about second marriages, second spouses a second ago, and the balance of concern. I want to take care of my spouse if I pass away, but I have children from a prior marriage, and I don't want their inheritance to be totally taken and given to my current spouse. Trusts are really good at that. That's right up a trust alley because it can hold the money in the trust, feed the income to the spouse. Under certain conditions, if there's a medical need, it can even dip into the money and help the spouse. So it's there, it's security, it's little income and security for the spouse. When the spouse passes away, the trust now will go over to the children. So it's really good, and you can tailor that in any number of ways. It's not uncommon to tailor the cash to be somewhat like I described, to say that the house, my spouse, if I die, my spouse can stay in that house as long as she wants to, as long as she can. Not until she's ready to leave does that house then go to my heirs. So I'm going to make sure she has a place to stay as long as she can stay there and wants to stay there. So trusts are great to protect that kind of that give and take between the spouse and heirs. But whether you're talking about a spouse or any other heir, there are a number of problems that beneficiary can have, and what we're really talking about most of the time here is protecting the beneficiary from themselves. So that can be substance abuse, they may have spending habits that you don't like, they may have marital problems, they may have certain risks in their life, and there may be some morality issues that you want to address. So we're going to talk about each of these just a little bit. Substance abuse is pretty straightforward, whether that's drugs or alcohol or any other substance. The way that usually gets solved is you just allow your trustee, the person that you've chosen, to withhold distributions. And there's usually some kind of a standard there. They have to pass a drug screen, they have to be so many days sober with AA, any kind of, you can set those standards. And if they pass those tests, they can have their distribution. If not, the trustee can just withhold it. Spending habits, that's also pretty straightforward to solve. It's not uncommon in a situation like that to say, okay, we're going to divide Susie's $100,000 by her lifespan when I die, whatever that is. We'll look it up in a chart. We'll see how many months that is. We're going to divide 100,000 by that. That's how much she gets per month. Basically, we're going to turn it into a stipend. So if she can't accelerate that, we put in a spendthrift provision, which means that she can't go down to the car lot and say, well, I don't have any money today, but look, I'm the beneficiary of this trust, so I'll have money for the next 120 months or 120 months, whatever. The spendthrift provision tells the creditor that they don't have any rights to lien, so they won't make a loan to her based on the trust. So they're protecting the beneficiary from themselves. Those are very common solutions. You can tailor those as you see your children, your beneficiaries. You can tailor those however you need them to be tailored. Marital problems, that's an interesting one. You may be concerned that one of your children's in a marriage that is shaky. You may be concerned that they're not married yet and you're not sure what kind of judgment they're going to have when they do get married. And you may, in a very rare instance, say, I don't want to be married at all if they're going to take the money. So if they're in a shaky marriage and you're not sure about it, you just keep the money in the trust. Go back to one of those other examples where the trustee has discretion, or you're just going to meter the money out over time. You can require, in a trust, you can require that your children have a valid prenuptial agreement prior to getting a distribution. So that any trust distributions would stop if they get married unless they have a prenuptial agreement. And you're not trying to make them agree on everything, you're saying you just have to have a prenuptial agreement to protect the money you're receiving from the trust. That's all it has to do. You can even restrain marriage. And this is a very interesting one. This is just an Indiana Supreme Court case last year. If you write a will and you say, to my daughter, Beth, providing she is not married, that is illegal. And the court will just read that, to my daughter, Beth, and stop right there. So it is against the law to make a will that restrains marriage. But there was a case that went all the way to the Indiana Supreme Court last year, and the court said, well, that's the law for wills, but that's not the law for trusts. So if you're in that and I've never had one come up like this, but maybe Beth has really, really poor judgment, and you just say, look, we got to incentivize her not to marry. You can do that through a trust. So you can make that trust condition on her remaining single. Yeah, that would be pretty brutal. I don't know, I would probably refer that out, to be honest with you. Risk in life, this is not necessarily a bad thing. If you have somebody that you really want to benefit from a trust, but they're an entrepreneur, or they're in just a situation where they may be under a lot of liability. If you leave them the money, that just dumps it into the liability pool. So the solution there is just to keep it in the trust. We can meter it out to them. We can have maybe a little freer reign. It's not that we don't trust that kind of a beneficiary, just we want to help make sure the money is there in case they do get into trouble. And similar to spendthrift provisions, we put in creditor provisions so that creditors cannot attack your beneficiary's interest in the trust. It's easy to do. So we can protect them that way. And that's usually done in conjunction with the beneficiary. The beneficiary knows you're doing that. They're on board with that kind of a plan. The last one I'll talk about is the morality issue. This is very tricky, but this does come up. I would not have guessed 25 years ago that it would come up as often as it does. But parents, for right or wrong, they have certain morality issues that they want their children to follow. And they want to be able to shut the money off if they're not following. Well, the trouble is, that's usually not something you can go out and measure. So you have to have the ability, with the trustee's discretion, to withhold the money. And that can create a very quick and powerful tension, and not a good one, between the trustee and the beneficiary. Because you're basically making their inheritance dependent on third-party judgment. When you get into a situation like this, it's not uncommon to use what's called a family advisor, and that insulates the trustee from liability. So I'm going to just make up a crazy example here and say that one of the morality clauses in the trust is that my children must regularly attend church. And if they don't, my trustee may withhold the money. If the trustee does that, the beneficiaries may go into court and sue them, saying that he's abusing that. We go to church online. He doesn't know that, and so it's all a misunderstanding, and he should give us our money. If the family advisor in the trust says, well, whether or not the money is going to be distributed is up to the family advisor. The family advisor doesn't have the checkbook, but the trustee doesn't write the check until the family advisor says so. We kind of separated the lock and the key. And it's much harder for a child then to go and sue the family advisor, because the family advisor said, well, what can I do? I was told to make a decision, I made a decision. I don't run the checkbook. And the trustee can go to court and say, I don't have anything to do with the decision. If I'm told to write a check, I write a check. So it makes it difficult at a legal level. It makes it very complicated at a personal level. So you just have to work through that. And there's no simple and even solution for that. And a lot of it depends on what it is that you want to ensure your children are doing or not doing. Some things are easier to address than others. Does that make sense to everybody, kind of about protecting beneficiaries from themselves and also kind of working between a spouse and child? We'll jump over now and talk about protecting the assets. You may have a legacy asset. That's something that's been in the family for a while, and you want to make sure it stays in the family, or maybe it's first generation to you, but you want to make sure it stays in the family for a while. It's not uncommon to have a cabin on a lake that you want to make sure stays in the family. And we can make that last for generations. It takes a good management framework, it takes some thought, but you can use a trust. By putting that asset into a trust, you can protect it and make sure it is there, probably for sure until your great-grandchildren are dead. So you can probably get to that generation easily. Also not terribly uncommon for a family to set aside a certain chunk of money for grandchildren. And they may not even know how many grandchildren they're going to have at the time they die. But we make it what is called a class. And so this chunk of money is for however many grandchildren I have when I die, or even great-grandchildren. So we're sending that money into the future, past the current generation, past the second generation, maybe even past the third. So you actually are protecting that money for heirs you don't even have yet. So that's how a trust can protect the assets themselves. Trust can also protect the value of the assets. So this is primarily a tax issue. We talked about this with the IRAs. It also is good with future tax law changes. Again, I think that the tax framework for federal estate tax and for Indiana's inheritance tax, I think that's very stable. Just that amount's going to fluctuate. But the idea that they're going to do away with the estate tax, they typically can't even get Democrats to vote for that because nobody in the heartland, the coastal people don't mind it. Everybody in the heartland doesn't like it, and it has to do with real estate. Charitable interests also can be addressed, and there's a number of ways you can actually weave your charitable giving into tax advantages if you use a trust. And that's its own seminar, so we're not going to go too far into that. There is a time to make a trust irrevocable. All the trusts we've been thinking about now, you can change them. As long as you're alive, as long as you're competent, you can adjust them, see how the family does, see how your wealth does. But there is a time when you want to make that trust irrevocable, which means you can no longer change it, and you can no longer get the assets back out of it. This used to be very common to reduce taxes, back when we would basically split the estate when one spouse died so that we had two taxable estates. If you remember, the slide I showed you on the federal estate tax had the ×2 for a married couple. That's built into the law now. Used to, we had to manually do that by splitting a trust in half. Irrevocable trusts now are very common to help protect assets from nursing home costs. The basic concept is you take the assets out of your name, 5-year look back, you gotta get past 5 years, but if it's an irrevocable trust and it's past 5 years, the government doesn't see it anymore. So you can qualify, as long as everything else is in line, you can qualify for Medicaid to help pay for the nursing home if you need to. You save that asset for your heirs, is what you're doing. You're giving up control, you're giving up most of the enjoyment for that asset, you can't get it back, it's irrevocable. And the control is now in the hands of the trust, so it's very important that we spend time and get that trust right. But if you do get it right, it works really well. So things that work well in that trust are your home, when you're pretty sure you're not gonna move anymore. Your home works well in there. Because the trust, if you need to, the trust can sell the home. It just it has to keep the cash. It can't give you the cash for the sale. If you have any kind of a second home, vacation home, anything like that, it works really well. If this is what you want to do, it works really well in an irrevocable trust. Farmland works incredibly well, and this is an incredibly great strategy for family farmers. They're never going to sell that land. So they put it in the trust. They get the income every year that the land produces, so that no change in their lifestyle. They just don't have the deed to the land anymore. And after 5 years, Medicaid doesn't see the land as their asset anymore. So that's really powerful for farmland. And it works the same concept if you have, and I've had some clients that come in and say, we've got $300,000, we know we're not gonna spend it. We're doing great with other money. So we want to put it in an irrevocable trust and basically lock it up for our future generation. And we'll put the money to work. We'll have Dave and Harley and Jeremy put it to work, and you'll get the income. That'll always come back to you. But that after 5 years, that money is just disappeared as far as Medicaid's concerned. So it's a really powerful, if you have the right assets and it makes sense to do this. You don't have to run out and do it just because it's a good idea, but if it makes sense to do it, those are the assets that work really well in there. Just remember, irrevocable is irrevocable, so you can't get it back. Question?
Can we put stock in there?
Mm-hmm. Yep. Yeah, and we structure these trusts in such a way so that when the assets eventually go to the heirs, the stepped up basis is preserved so they don't get hammered with capital gains tax. There's a number of things that we do to make it, if we're gonna put it someplace where you can't touch it anymore, then we wanna make sure that we do everything right. So it does work well for things like that. And then the last concept I want to talk about tonight is what's called a trust protector. And this you're probably going to start seeing in advertising before long. It's the way that law firms work. So a trust protector is different from the trustee, different from the family advisor that we talked about before. The family advisor is there basically to make difficult decisions for the family. A trust protector, who is usually the attorney, is there to make sure that after you pass away, the trust doesn't get into legal problems. And that usually translates to tax issues. So if there are tax issues that arise after you pass away, you've named somebody that actually has the power to change your trust, even though you're passed on. And they can make that change to accommodate for the tax laws. And that's actually not that uncommon, and it's kind of useful. In the past decade or so, there's been a lot of changes where we can actually make trust more advantageous. So if we have the power to do it, we do it. You can also give the trust protector the power to make those difficult decisions. To shut the trust off, to exclude a beneficiary. I'll give you it's not a real life example, it's just a tragic what if. Let's just say that you set aside some money for 3 grandchildren, and one of those grandchildren is involved in a horrendous wreck or something, and they are going to be compromised and basically disabled for the rest of their life. They're going to be on Medicaid, they're going to be receiving government benefits, and everything that comes out of that trust is just getting sent back to Washington. The trust protector could step in and change your trust to be a special needs trust and protect the money. So it's a humongous amount of power to leave to somebody. So I don't say you rush in and do that, you know, and I'm not trying to scare anybody into thinking that, oh, you gotta protect your grandkids from, you know, horrendous crashes. But if it's out there and if, you know, if it is something that keeps you up at night, there are ways that we can make sure somebody has the ability to do that. Does that make sense to everybody? Excellent. So trust, again, they really are superheroes. They can do just about anything we need them to do. We protect the beneficiaries. Sometimes we use a family advisor to do that. Protect the assets, protect the wealth, so we protect against taxes. Find that irrevocable trusts are useful, and there may even be a place for a trust protector in that plan. So that is where we are. About 45 minutes, so we're right on time. We talked a little bit about taxes not being a major issue as far as the changes in the tax laws. Everything is really pretty stable, pretty good there. Digital assets are also very stable, but make sure that you know somebody or have some provisions for somebody to be able to get to those. Healthcare laws are changing for the better, so if you're going to update your documents, you can take advantage of that. If nothing else, if you take nothing else away, think about how you're going to coordinate the IRAs with your estate planning. If the beneficiaries are good, you're good to go. If you've got problems with the beneficiaries, then there are ways we can address that, but frankly, one of the best ways to address that may be to convert it to a Roth. Pay a little bit of money now to take full control of it. And just remember that trusts are there if you have problems in your estate, if you have problems that, you know, if your beneficiaries are keeping you up at night, trust can probably solve that problem. So, any questions about anything that we covered? Or? Very well, thank you all very much. This was the first night for this presentation, so I am really interested in any feedback you have. And I have very thick skin, I'm not worried about it. So if it bored you to tears, I want to know, and we'll work on it. But if there was something in here that piqued your interest or that was beneficial, let me know that too. If there's a legal topic that you would like to put pressure on those guys to have covered, I'd be glad to come and talk about it, but they need to know. And so if you just take a couple minutes and fill out the feedback form, that'd be awesome. And other than that, there's still some snacks back there, and you guys have been great. Thank you very much.
Thank you.
You have a card that I can hold up your I think I might have it at home anyway, but well, get another one.
Creates a lot of questions too.